This is Jody Daniels, CEO of Red Clover Advisors. We are so excited that you are here with us today. And I have brought with me some amazing privacy rock stars to join me. Just a brief blurb. Red Clover Advisors is a data privacy consulting firm. We are helping companies operationalize privacy. So the long list of requirements and to-dos that you're going to hear about today, or maybe is on your list to tackle in January, we would love to be able to help. So we try and make privacy simple. And one of the ways we do that is through education and these types of webinars. So Laura, I would love if you could introduce yourself.
Well, thank you so much for having me, Jody. I'm Laura Van Druff. I'm the managing partner of Kelley Drye's DC office, where I practice in our privacy and information security group. I spent almost a decade at the Federal Trade Commission with my friend Molly Crawford, and also was spent a little bit of time in-house at a major telecom.
Amazing. Molly.
Hi, I'm Molly Crawford. I'm the head of public policy at the Interactive Advertising Bureau. As Laura mentioned, I recently joined IAB after 20 years at the FTC, where I got to hang out with good friends like Laura, and excited to be here, Jody.
Well, we are so delighted that you are here, and I'm excited that you are at IAB. We are an IAB member, and it is just lovely to have you there. So, a quick housekeeping item. People always ask, is it recorded? Yes, this will be recorded. And we would love to make this interactive. So there is a Q&A button somewhere. Chat doesn't work. It's been disabled. You know what? Thank you so much, but I did not appreciate that. So we will have to play the bagel game another time. If you've just joined and you're wondering why are we talking about bagels, it's because I originally asked, what is your favorite bagel flavor? That was our fun conversation in the pre-show. But now back to privacy. If you have privacy related questions, please put them in the Q&A, which is not disabled. Now, why are you all here today? You are here because these are the topics we want to cover. We want to cover what actually happened this year. What can we learn through enforcement actions and activity from the FTC and the states? What are the key trends that are going to shape 2026? What are common gaps that might trigger a regulatory investigation and how to address them? How might you build a defensible privacy program that align with regulatory expectations, and what you should start prioritizing right now, or at least put on your to-do list and remember to do when you come back in January after you remember your password. And I mentioned Q&A. We're going to want to answer those questions, and we have all agreed, let's make this an interactive activity. To get this started, we're going to start with a poll first, and then we're going to dive on in. So preparing... That was not the poll I wanted to do, but we're going to do it backwards. It's okay. It's okay. Jody should not be the poll creator. Preparing for 2026 privacy obligations. What feels like the hardest part of preparing for 2026? Is it hard to be the crystal ball and predict regulator enforcement priorities, fixing operational gaps, managing business demands while tightening compliance efforts, getting ahead of new state law requirements like children's privacy and sensitive data rules, or just some combination of all of it above? I see we still have some people participating. I'll give it just a few more moments. I won't sing. I might later. Okay. I'm going to end our poll, and I'm going to share the results. Well, about half of you are trying to manage all of it, but the leading piece here is fixing the operational gaps and legacy processes. And I think through our conversation here today, we hope to be able to help prioritize which ones of those you might want to lead with based on where we're going to start seeing some more enforcement activity. So with that being said, I'm going to stop the share and invite our conversation. But first, I actually see we already have we had a hand raised. I'm not sure. If you need something, hand raiser, kindly put that into the Q&A and we will try and address that. All right, so let's kind of get started. Who wants to kick us off with a little bit of the lessons? Let's start with our friends at the FTC. And Molly, maybe I'm going to give that one to you because you were the most recent person there.
Sure. Well, I think the FTC continues to really push forward in the privacy space, including under the new chairman. We've seen a number of sort of continued work in the world of privacy. One of the things that I think is really interesting that this particular commission has emphasized is the importance of children's privacy and online safety more generally. We've seen cases like the Disney case that they brought, but then also workshops, including I think they just recently announced the age verification technologies workshop that they're going to have in January. So, it strikes me that especially when it comes to kids and online safety, much like the broader policy conversation, that's going to continue to really drive the day at the FTC.
Molly, for those who might not be as familiar with the Disney case, can you give sort of the elevator version of what that case is?
I'll do my best. So Disney actually had a settlement with the FTC involving their YouTube channels or their YouTube videos, I guess I should say. So, under the FTC YouTube case, there had to be a way to mark things as for children or not under YouTube. And so, while Disney did have a process to put the channel itself under for kids or not for kids. Some of their videos ended up not being marked individual videos, which then led to a law enforcement action. Laura, I hope I got it right. I didn't buff up on my reading.
And Molly is pointing to me because we represented Disney in that enforcement action, and that was well articulated.
Oh, good, good. She was going to tell me if I got it wrong.
Amazing. Well, Laura, we had a lot of state enforcement activity, significant amount out of a large state out west, known as California. And I have seen some common themes that have come out of them. Interestingly, children was one of those big ones. We've also seen children out of a case in Florida. Laura, can you maybe share what are the big highlights for you that you've been seeing out of the state enforcement actions that we've had so far this year?
Yeah, happy to address that, Jody. So, I mean, state regulators certainly are expecting that companies comply with their laws. CCPA has been on the books now for years. We're past the point where regulators have patience with companies that just throw up their hands and say, this is too hard. That's particularly the case as it relates to consumer rights and particularly the right to opt out. So we saw that in a number of the enforcement actions out of California this year. But we also see that in the sweeps being announced, including most recently by the consortium of privacy regulators who are looking to see whether companies are taking steps to honor GPC. So, that I think what's old is new again. The states are concerned about these most fundamental rights that their privacy laws provide to individual consumers and making sure that companies are honoring those.
Yeah, I was talking to a company yesterday and they were really focused. What do I need to do for January 1st, 2026? We started talking about the new regulations that were coming. And part of our conversation was actually exactly what you just said. The main parts of the law have been around for a long time. They're expecting you to have a privacy notice that actually reflects what you're doing. They're expecting that the ad tech pieces and opt outs and cookies and do not sell and share and privacy rights forms, those are functioning
Mhm.
properly. There's, I think, a lot of companies that are still needing to get to that part as well. And so I just wanted to really echo the basics. If anyone listening, if that is where your 30% of fixing the ops and the legacy processes, I'm going to encourage you to go there. It's what any regulator can see on the outside. I don't know if Laura, you have anything you want to add
Yeah,
to
no,
that.
that's exactly right. So regulators are people too, like an Us Magazine spread, but they are on the internet. They're engaged in commerce, not even necessarily as part of their enforcement actions or sweeps, but instead just as individual consumers. And when they have an experience that doesn't align with what the law requires, that's where companies begin to get in trouble. And just having a cookie banner does not mean that you're complying with the law. You need to really think about how your tech is working on individual pages and whether you're effectuating consumer rights.
Molly, I saw you nodding. What would you like to add?
No, I mean, Laura's hit the nail on the head. They're consumers, but also I think we see regulators are really tech savvy. They are also monitoring the traffic that is happening. So while they may not know why, they can certainly go to websites and they can see that cookies are being dropped. They can see that there is an exchange of data. And that's the kind of thing where if something doesn't seem right, I think you could expect a regulatory inquiry because that's a pretty easy starting point.
And I think the other thing to emphasize is we have some enforcement actions that were public, but that doesn't mean that that's all the inquiries that might have happened to companies.
Mhm.
And I believe a lot of times companies think, oh, well, that was it. There's nothing else I need to do. And for many of you listening, you might need to communicate upwards why you need resources to be able to continue on this effort. And I'd love to be able to help you with that as best as we can in protecting the innocent. We have a consortium of state regulators. They are talking amongst each other. We have sweeps that are going on. We have not seen the output yet of what will happen with that global privacy control sweep, but we know it has been out there. And then companies might get a letter and maybe they're quietly sort of sorting through that. Laura, obviously, with protecting all the innocents, if you could just share a little bit more about that detail, because you see, so many of those types of situations, that might be helpful.
Yeah, happy to do that. I mean, certainly, a regulatory inquiry, it imposes a burden on companies. It's not, the burden takes a number of forms, right? It diverts resources from the business, which itself is an impact, but also, the necessity to engage counsel and undertake, that back and forth, the communication with a regulator, that is time consuming and it eats resources. So it is certainly more efficient to do the work at the front end, which you described really beautifully, Jody. The basics, right? The low-hanging fruit, so that the consumer doesn't complain about your site and how things are working, and the individual regulator, when they're visiting with the tech knowledge that Molly described, that they don't see things that are unexpected, because that is where things begin to unravel. Certainly not every investigation is going to necessarily result in a public action, but that doesn't mean that the company that was the target of that investigation, or even an informal inquiry, didn't have to really direct resources to that in a way that was disruptive.
Yeah, really, really well said. And I will say, when we go and are looking at sites, Laura, I'm sure you've done this, and Molly, you've probably had a lot of conversations with companies. We are seeing, oh, something is often broken.
Mhm.
We haven't really yet seen a cookie consent setup that didn't break for some reason. And it might have been set up properly, but it's on a website and the website might have had an update and something happened. Or there was a privacy notice update and the link in the privacy notice no longer actually connects to where you thought it was going. Or the privacy rights form somewhere along the way didn't actually happen. Or the person who was managing the email doesn't manage the email anymore. I encourage everyone to do like a privacy external audit of your site. Either you do that, have another team member do that. We've done that for companies, but someone needs to act as an outsider and click on all the links and come from the lens of a customer and a regulator, because the regulator is a customer and they are coming. And if you have friends in the privacy space, y'all can help each other. You can
Kick the
do this. I have
tires.
found a lot of problems, and I just go find the privacy person and very nicely tell them, you got to go click and fix this thing over here because it's not working. So we as an industry can also help each other because that's what we're here to do. But let's talk about where some of those issues were. So we've talked about opt-out was a really big one. Privacy notice not actually disclosing what it was supposed to be doing. The privacy rights forms not working. My favorite that I've heard from regulators, they're using the privacy rights form to send you the inquiry, people. Let's say that again. They're using the privacy rights process to send you the inquiry, test your process. But another one are the contracts. And Molly, I know that this is an area that the IAB can help in, especially when it comes to ad tech. And maybe not everyone appreciates the complexity of these contracts and what some of those solutions are. So I was hoping you might be able to help us explain a little bit of the contract fun and maybe how companies can sort through that.
Fun is a relative term, but
But we're all amongst privacy people, and this is fun to us.
right. But incredibly useful. So, one of the things that my colleagues at the IAB have put together is the multi-state privacy agreement. And what that is really built to do is to address the contractual obligations that various state laws require on different entities, be them processors, be them service providers, third parties, et cetera. And so we ask companies to sign on to the agreement, and then you can use this contract with other multi-state privacy agreement holders to really fill in those contractual gaps that you might have in terms of compliance purposes. And it is targeted really to the ad tech industry, just given its complexity, but it's also quite handy, I think. And we've seen a lot of people adopt these as a way to help, at least in their due diligence portion, have some really good guardrails.
And Laura, what about beyond the ad tech piece and making sure that we have contracts in place with our
Mhm.
vendors? Where are some of the challenges you see that companies have and how you all are helping to resolve those?
It really depends, Jody, on the sophistication of the individual company and how mature their privacy program is. It really runs the gamut from what is my vendor? Is my vendor a controller? Is my vendor a processor? And then structuring from there, what the appropriate contracts are going to look like, including things like audit rights and what we're doing to do diligence at the front end and during the operation of the contract. So, the pain points really depend on the individual company and how sophisticated they are. So we have clients with, templates, and they're, ready to go. And we work on, the edge cases to, clients that just need to understand the process so they can set up that internal process themselves. And none of it is easy for anyone.
No, for sure. Now, we talked a little bit about Disney and kids on the FTC side. We also have the interesting Roku case that came out of Florida, and kids are also a hot topic. We've talked about the age verification workshop that's coming up. So, again, I was hoping maybe Molly, you can share a little bit around kids. What should companies, I mean, as a parent, I hope everyone's caring about kids. If you work at a company and you are managing my kid's data, please care about my kid. But overall, can you help us understand where we are from a kid's privacy point of view and what companies should be on the lookout for?
So I think we are in a, I mean, I think we have always viewed children as a specific class of consumers that warrant sort of special and stronger protections. But currently, the political and the policy climate is really focused on these individuals. And it's not just COPPA kids under 13. This is really minors under 18. Both, we're seeing the introduction of a number of bills at both the federal and state level that really try to go after how to protect kids in these online settings, in app stores, in with AI chatbots. I mean, you name it, children are really the topic to end all topics. So to the extent that you are in the business of children, or that you may in fact have children's data, this is an area where I think both the legislative and the regulatory bodies are putting an enormous amount of effort. So it's the kind of thing where you would really want to go back and look and dot your I's and cross your T's to make sure that you are treating this information the way you ought to, not collecting it when you shouldn't, and having a really mature process to deal with it.
And this gets tricky, Molly, for companies that have been thinking in a COPPA-like framework, right? We've had COPPA for a generation, and children under 13, most companies now understand how to proceed with that. But when you're talking about minors and whether you can reasonably infer that you have minors on your site, or even a knowledge standard, if the app stores start passing a signal, things get complicated quickly for companies that weren't in a COPPA space but may be serving minors, because of course minors are on the internet. I mean, they necessarily are, just by dint of having a laptop for school or otherwise.
You're right, Laura. And this is only going to get more complicated. The House Energy Commerce Committee is going to mark up, what is it, 18, 19 just kids bills on
Laura.
Thursday.
Yeah.
So, I mean, there are things that are moving. Obviously, whether they pass or not is a different question. This is the same thing happening at state houses across the country. So, come January, if something didn't pass, I'd expect to see it again. The compliance regulatory framework is just going to keep changing, but people really need to have their eyes open as to what's happening with those consumers.
Laura, you said something around the knowledge standard and then also on the app side. So I want to put the app on the side for a second to talk about those signals. Can you share a little bit more? What does that reasonable standard of knowledge mean for a company?
Right. So this is important to distinguish from the sort of COPPA standard of whether a site or service was directed to children to whether a service has either actual knowledge or constructive knowledge that a minor is on the site. And that really is a paradigm shift because the FTC COPPA rule and guidance around COPPA makes clear sort of mostly clear what is directed to children. And it is, for most companies, what you think of as what kids like, whether it's, something cartoony with songs that kids like or otherwise. But when it comes to knowing or having constructive knowledge that there are minors on your site, that gets harder, right? Because again, children navigate the internet freely at present in all but a couple of states as relates to pornography. But here we are, and so it is going to take a lot to reach a consensus before there are actual age signals about what that means. And I know you asked to set aside apps for a minute, but there will be age signals. The app stores have said as much to comply with Texas and other laws, and that is going to be a reality that we're living in shortly.
I definitely want to get to that, but I want to go one back.
Yeah.
Constructive knowledge. What should a company reasonably consider to be constructive knowledge? Is there any more that we can add to that?
Well, that's a great question, and I mean it's going to depend very much on the circumstances that a company faces, of course, and that's the lawyer's answer that no one likes. But but it is important to really evaluate what you do know about your audience. So what kinds of data you're getting about that audience, and whether you may reasonably infer from that you have minors on your site, because there may be circumstances where a regulator holds you to account for the fact that you've got minors, and based on the sum of the data that you collect, even if you're not using it.
All right. Oh, go ahead, Molly.
No, I was just going to say, like to Laura's point, to the extent you've got videos and regulators or staff or members of Congress can go see, those are clearly children on your site because there are videos of them. That's the sort of thing you'd want to certainly be prepared to deal with.
That's a great observation. All right, Laura,
Even, and
apps
I'm sorry,
and
I just
signals.
to belabor the point for just a minute, but even if you have survey data about what your likely audiences are, and that audiences may include consumers under 18, that's something to consider.
Excellent. So, I do want to go to signals for everyone listening. What comes to mind for me is data inventory. You got to really know the kind of data that you have and what systems that it's in and what your products are doing. That's going to help fuel these privacy decisions. Apps and signals. Laura, help us understand this app and signal situation coming up here.
Well, I don't know that I can really provide too much clarity because we don't know exactly what's going to happen yet from the app stores, but they have indicated that they will send signals of what band an individual user falls into. And so we'll go from maybe a constructive knowledge to an actual knowledge that a user is between 17 and 18, between 15 and 16, under 13. And that is going to be a game changer for many companies.
Okay, it is the perfect time for a poll question. And while we do that, I want to remind everyone that if you have a question please put it in the Q&A. We've had some people join since I mentioned that before, and I wanted to remind everyone. Okay, so as we head into 2026, what is top of mind for you? Is it reviewing and strengthening core privacy practices, balancing business needs with evolving transparency and consumer expectations, preparing for emerging privacy obligations, or avoiding regulatory enforcement actions?
Select all is not a choice,
I
Jody.
did not give you a select all here. I am forcing you. You got to pick one. You got to prioritize. You can change it next week. It's okay. All right, few more votes in. I always find these polls so fascinating. All right, gonna end. I'm gonna share because we have a kind of close-ish tie. So the leader is preparing for emerging privacy regulations, followed by reviewing and strengthening core privacy practices, then balancing business needs with evolving transparency and consumer expectations. And less than 10% of you are trying to avoid regulatory enforcement actions. And I love that because the reality is if you're doing the core privacy practices, then that should not be the priority because you will have been doing the steps that you need to be doing, and then they won't come bother you. It's wonderful. Okay, so with that being said, our other main areas, sensitive data. Let's talk about sensitive data. So Molly, help us understand the universe of sensitive data and what companies might want to think about when it comes to that type.
Again, sensitive data, and children is obviously a subset of that, but you also think health data. I mean, there is still a lot of real interest and inquiry into those spaces. I think, I would put children and health in sort of the top two buckets for 25, 26. But that said, the states have all taken very different approaches to what they define as sensitive and how they define it as sensitive. So we're also looking at, again, the patchwork. Precise geolocation is also continues to be, I think, an area where we're going to see a lot of movement. Those are sort of the three biggest buckets, but that's not to say that it won't change. I mean, for example, we have the New York HIPAA law sitting on the governor's desk that may, in fact, greatly expand beyond what most people were expecting, what the definition of health data may fall into. So those are sort of the biggest classes of data. But honestly, this is going to be one of your great 50 state survey questions where you get to go through and see all the things that you do that may in fact be sensitive. But those are probably some other areas where you're much more likely to get regulatory interest just because they are sort of a heightened class of information.
And
And
Molly,
the
I think it's,
challenge, oh, go
oh,
ahead,
sorry.
Laura.
No, I was just going to say, I think it's important to pause for a moment on health because, and you alluded to this exactly, that the states, particularly blue states that are concerned about the fallout from the Supreme Court's Dobbs decision, are taking a more expansive view of what constitutes health information. And companies that, maybe didn't think that they were in that space as it comes to, non data that's not subject to HIPAA falling into scope, not paradigmatic health information. But excuse me, Jody, I didn't
Oh,
mean to
no, no,
interrupt
no.
you.
It's a perfect segue because one of the big challenges that companies have is the definition of sensitive data is different. Part of the definition of health data is also different. And while there's definitely not a perfect way, Laura, I was wondering if you might be able to offer how companies can help attack these at least 19, but really more because we have Washington for health and then we just, keep on going. So we're nearing 24 different lineups at a minimum that a large company might need to manage.
Mhm.
How are you seeing companies really try and tackle this problem?
Yeah, it's a great question. And it's important to establish for any company sort of what your priorities are. And I think that that's the nut of your question. And what I for most clients, the question is, where your risk is. And I appreciate that our audience isn't really focused on avoiding regulatory enforcement. But when it comes to um, the thinking about your privacy program and whether it will attract attention, how to prioritize those the gaps that are the focus of most of our audience. Where we want to tackle it is where we have highest risk. And I'm glad that you asked about sensitive information, because that's the right place to start. Is that sensitive information presents the greatest privacy risk. And so, if you don't, for example, have the data inventory that you described a few moments ago, Jody, it's really hard to know where to begin. So for some companies, it's important to just establish what it is that we hold, and then to sort of tackle things piecemeal to make sure that the right controls are in place first for the most sensitive of the sensitive information, and working waterfalling from there.
Yeah, and we're seeing, for me, this also is going to tie to privacy risk assessments.
Mm-hmm.
And what does your privacy risk assessment process look like? This is going to then tie to the upcoming CCPA regulations that you're going to need to be thinking about. And we have ad tech that might be part of this. What is your documentation that you're going through? So all the ops, and actually, I'm glad I asked about where people were starting at the beginning, because fixing those ops and legacy processes is so important as it keeps getting harder. And I don't think we have figured out on our call today that it's getting easier. It's going to be very important to have a strong foundation. And I think a strong foundation is starting with the data and then building the process. How are you going to capture the new changes that happen in the organizations? Ad tech is one of those. So we've talked about kids, we've talked about sensitive data, we've talked a little bit about the contract side for ad tech. And since this is such a priority area, Molly, I was hoping maybe you can share a little bit about some of the trends that are happening or what you're seeing companies do to try and help tackle the really complex universe of ad tech.
Well, again, I'll pivot to they are using our MSPA, but they're also using our other tools just in terms of diligence about the kinds of companies they work with. So, one of the things that we've done at IAB is help put together a questionnaire. So, when you're engaging in diligence, you actually can ask sort of ad tech specific questions, if you will, to players in the industry. But look, this is just hard. It is complicated. I mean, I work with experts in ad tech and it can be hard to explain. So what you really want to do is have a lot of cross organizational communication, because it can't just be the lawyer sitting in one bucket and the sales and marketing in one bucket and the engineering in one bucket, because it all is going to swirl together in a big soup. So in that space, honestly, the people that I find that are most effective are ones that really engage across their organizations and who do it early and often. They don't wait until they hear a problem. They sort of engage and are really curious about what's happening on the business side so that they can help advise and identify risk, to Laura's point, earlier in the process.
I think that's such an important observation, Molly, that the most effective privacy programs aren't privacy programs. They're embedded, throughout an organization. And that gets to your point also, Jody, about resources that hopefully a privacy program that is functioning the way Molly just described doesn't need to advocate as loudly for resources, because it's evident to the business that those are needed for privacy to offer those supports at every stage in development, and to avoid just foot faults, which is where a lot of companies find themselves.
And I was at a breakfast this morning with a number of people in the industry, and one of the things that they talked about was this sort of cooperation. And I thought was so interesting. They were speaking to the marketing people, and the marketing people initially said, well, no, we need more data. We need more data. And then she kept asking, but why? But why? And then by the end of the 15-minute conversation, it was like, oh, we actually don't need that because we don't use it for anything. So being able to have those conversations at the beginning, I think really helps you avoid a much more complicated or difficult conversation on the end part.
That privacy by design and building relationships is so important. Before you shared that story, I was going to mention that, Laura, you were talking about the different groups coming together. And I think it's so critical and important to make sure that that's what it is that you have. You have understanding of your products, you have understanding of the kinds of data that you have in your organization. So do you have sensitive data? What kind of sensitive data? Do you have kids data? Are you doing targeted advertising? So if you're listening today in our audience, and maybe that's an area that you're a little fuzzy on, I encourage you to go meet the people to help you get really solid on the product or the marketing activities or the sales activities. If ad tech is something that you need to learn, IB has a long list of wonderful resources. The internet is at your disposal. These things are complicated, and the more information you have, I feel like the easier these conversations are, and then you can start pulling it in earlier to get to exactly where Molly you just described. The marketing team realized, "Oh, maybe I don't actually need all that data."
Might I also suggest, I have found dark chocolate peanut butter cups from Trader Joe's to be an excellent conversation starter.
It's
Should
funny you mentioned the
bribery be
candy
your
part. I've
strategy?
had this conversation with many people. So for those of you who are in person, there are a lot of people that strategically put candy at their desk.
Mhm.
And then magically, you're the fun office because you were there. And if you are remote, that's okay. You know what? Virtual coffee cards are great. Buy someone a cup of coffee for $5 and it will be so incredibly worth your time, or just bring it from your own kitchen and have a virtual coffee date. But those conversations and relationships and putting time on the calendar, that is invaluable. We can talk about AI and automation, but what people are doing in companies is using data, and that is from a conversation. I just cannot emphasize enough. You have to talk to the people to hear what it is that the people are instructing the systems to go and do. It's still people, not robots yet. And even if it's robots, it's still a people person, at least first hiring a robot. Um, okay, so let's talk a little bit about what's on the horizon, because first, we've actually had a lot of amendments this year come in. We had Connecticut, we had Colorado, we had a number of amendments. We were so close to a particular state. And Molly, I'm going to let you talk about that particular state and what we might see in 2026. So what's our policy crystal ball that we might see?
More, more,
More.
more.
See, I told you I was
26.
going to say.
I know 2026 is going to be more. So to Jody's point, I think we're going to see more amendments to existing privacy laws as regulators, as businesses, as legislatures are seeing how they're playing out, where their gaps may be, or maybe just responding to sort of external market forces. For those states that don't have privacy laws, they are certainly still in the works. I expect Massachusetts to pick right back up in January where they left off and continue to move that ball forward. I think you're also still going to see those sort of particularized privacy bills in things like the kid space, the health space, the geolocation space. The fun is just going to keep on coming from all sides. So happy 2026, everyone. But I don't, my crystal ball is that while we will talk about a federal privacy law, I would be really surprised if we actually get a federal privacy law. Obviously the House ENC hasn't released the text yet. That's still to be determined. I'm sure the shutdown didn't help that process. But from what I'm hearing at the moment, it sounds like it is a fairly one-sided conversation. So TBD on how it will be received and move forward in the process, but the fun is in the conversation.
Well, even the conversation about the kids' bills, which would preempt state law, suggests to me that we're not getting far fast as relates to a comprehensive privacy
I
at the federal level.
Even if these things move along, I think the Senate and the House have some real disagreements in their language about how they would like to proceed. So maybe they need dark chocolate peanut butter cups from Trader Joe's.
Laura, do you have any thoughts of where you think we have more? We have a lot that companies are trying to manage right now. What might you suggest from your lens that companies focus on in, we'll just go with the first half of 2026, because who knows what will happen for the second half.
Well, for companies who are not, going back to the start of our conversation, sort of focused on the basics, needing to remediate the basics. One thing that companies are going to need to think about in 2026 it relates to automated decision making. This is an area of significantly increased risk because regulators expect companies to have processes by which they evaluate whether the there's an automated decision that has a significant or high impact on consumers. And so, that those processes are new, and it's going to take some doing for companies to get there if they're engaged in automated decision making in a way that is high risk.
So, in that vein, for those companies who need to tackle automated decision making, are there any process steps that you're seeing companies begin with?
Well, going back to sort of, what do we have and what are we doing with it is absolutely essential for that process. It's not a step you can skip. It's necessary to really identify for which processes we need to do this risk assessment, and then you can tackle sort of the issues that are identified in the regulation. How to answer those questions. But before we even know what we're aiming, we need to decide what we're aiming at first. And for every company, that's going to be different. And there are maybe, some companies that don't have to tackle this, but it's going to be important to go through the process of knowing that you either do or don't need to tackle it.
That makes sense. So, we have a question I want to go to, which is what do we see for higher ed organizations and what is coming around for privacy and any differences? Any thoughts?
So, Molly, I'm interested in your take on this. I was grateful to have an opportunity to listen in on a call with the Future Privacy Forum had with the staff responsible for the kids bills, and a related question came up from their audience, and the answer from the staff was, "Gosh, we didn't know that there were unique issues in education, and oh, by the way, energy and commerce doesn't have jurisdiction." And I am absolutely summarizing, but I thought that was interesting, because FERPA has, like COPPA, has been around for a long time, and hasn't been updated really to contend with all that's new. But Molly, I'm interested in where you are.
Well, I don't think there's anybody much left to update FERPA at the moment, so that makes it slightly more challenging. I mean, look, higher education institutions have had themselves a banger of a 2025 that have very little to do with privacy. Um, I would not be surprised if some of that bleeds into 26. I don't know that there are any specific issues that I'm seeing that are targeting those institutions, but certainly the data they collect and really for other purposes is candidly something that I think should be at the top of people's mind. Obviously, issues around the scope of the of what sort of lessons are being taught at higher education, the kinds of courses, but also who is attending them are really of interest to a number of different organizations. And again, these may extend even beyond a conversation with the privacy program, but not seeing anything specifically targeted to that group. But that said, that doesn't mean you won't have an unexpected consequence of of language surprise you.
Amazing. Well, one of the topics that we said we were going to talk about are defensible privacy programs. So, Laura, I'm going to start with you. If you could help us understand what is a defensible privacy program? When we say that, what do we mean?
So you want to be in a position to describe to a regulator what it is that you do to ensure that you are to work toward complying with state privacy laws. And we've identified sort of regulators' top priorities include things like operationalizing privacy rights. And so as opposed to waiting for a single consumer rights request to hit the privacy inbox, that you have a routinized process, that it's written down, that people are trained on it. Those are the basics when it comes to a defensible privacy policy. And then depending on what information your organization collects, how it processes it, that will determine the additional sophistication that's required to layer on top of that.
And Molly, what about you? How would you add on top of what Laura's just shared so far?
Laura, I think really summarized it nicely. The one extra piece that I always think would be helpful is to build redundancy in. You got to assume that something that you're doing is not going to work. So to your point, Jody, the broken links, the site to nowhere. That so you want to have a program that also has redundancy and knowing that something's going to go wrong with whatever you have built. So what is the second layer that you have in place to catch something that you may have missed, essentially?
Molly, that's such a great point. And another thing that is really helpful as counsel representing companies in investigations is describing exactly that process, right? That we did identify that there was a glitch on the site that for 4 days that meant that we weren't honoring GPC. The way that we caught it was, let me describe it to you, and here's the steps that we took to fix it before anyone even bothered to tell us about it. We didn't wait for a regulator inquiry. We didn't wait for a consumer complaint. We dealt with it expeditiously.
Mhm. And if for some reason the process didn't work as well as you'd like, that's a really great lesson learned to then update the process and the program. So, oh, this could happen. How can we avoid that the next time?
Yeah, so I think the controls, having a method to actually test. I mean, we say this all day long. You got to test cookie consent, you got to test privacy rights, you have to test all the processes. At the same time, it's building in controls to be able to capture the change. And for me, the other piece I would add is especially if we're doing risk assessments. I'm deciding, can I do this? Should I do this? Legally, you might be able to figure out, okay, you think you can. And then, kind of like Molly, to your marketing question, it's, well, should I? Do I really need that information? And the more you keep going down, I always like to encourage people to think, okay, so think the worst case scenario that could happen. What would you be able to respond with? Did you document what your reasons and rationale was? Someone might not agree with you, but at least you'd actually have, well, here was my thought process, and I did that. I actually believe that's why documentation's becoming more of a requirement
Mhm.
across different laws. Minnesota says you have to have an internal privacy policy. GPR says you have to actually do a risk assessment. Our other states are saying do a risk assessment. Why? Because otherwise, I could just have this lovely conversation and then I never documented it, which means I never actually had the conversation. You weren't forced to think about the hard questions. So I'd encourage people here to make sure you're thinking about the hard questions. And I'll add one more, which is also going to tie a little bit to UDAP laws and customer expectations, because a lot of times I think companies want to use the data and they forget about the customer. And especially on privacy rights, I find the people who exercise privacy rights are mad at you. You have done something wrong. Happy people tend not to go and submit a form unless they're really privacy friendly or forward people. But there's like all of our privacy community might be that. We still make up a small group. So if we think about our customers and our consumers, I think it's important to think about them first. And Molly and Laura, both of us, we had been talking about UDAP, where we have privacy laws, but then we also have some of these other issues that are popping up. And I'd love, Molly, if you can maybe start us with talking how companies have to start thinking about the deception or dark patterns or confusion that might happen based on how we might be collecting or displaying information.
Absolutely. For those states that don't have specific privacy legislation, and certainly for the FTC, they're largely relying on those sort of UDAP laws, are so deceptive and unfair practices. And Jody, I think your point about dealing with it from a consumer perspective and the consumer first is such a great way to go about it. I mean, again, we are all privacy people, but we are also all consumers. So it is certainly a space where really building that perspective in what consumers expect. Did you tell them something? Would they be shocked if you had told them and would not have liked that? Those are really good places to sort of think about that experience because it's certainly a place where, from a law enforcement perspective, you could receive an inquiry, especially when people don't have a specific tool or a tool that doesn't necessarily reach all of the conduct that they may be interested in.
Yeah, I mean, I couldn't agree with that more enthusiastically. And I think, it's instructive to look at what Texas has done before its privacy law took effect. I mean, it made great use of UDAP to pursue a number of companies in the privacy space. And this very conservative attorney general, conservative politically, received just press cycle after press cycle that was positive. So I think we're going to see more uses of UDAP in states where they don't have comprehensive privacy.
Yeah, so even further emphasizing the need, privacy can't live in a bubble. It has to work with its other partners. And you need to think not only of privacy requirements, but really of the customer holistically. And kind of in that vein, that to me is transparency. We have a question here about what about updating privacy notices for AI uses and chatbots and sort of emerging technology like that? Laura, I'm going to see if you have any thoughts
No, right.
on those first.
We certainly do get that inquiry, and of course, it's not legal advice to share with you that it is going to depend on the use case and on how data is being used. But providing transparency to consumers where a state law might not otherwise speak to it, there's the downside to that transparency is then you're held to that representation. But where companies are crisp about how they're deploying AIs in a chatbot, for example, then it's important to disclose that, and so that there isn't any mismatch between consumer expectation and consumer experience. For example, even the fact of a chatbot, it is useful and required in some states to disclose that it is not a human that you're interacting with. And that can really help to just align expectations in terms of the customer service that you're going to receive.
And that dovetails really nicely into the conversation we just had about UDAP laws, which is, I mean, the FTC brought cases challenging the use of AI in deceptive practices, for example, because there is not an AI carve out for a UDAP law. So that is another place where, again, that consumer-centered experience, that consumer-centered focus, I think is really critical because and you even see press articles about companies that may have deployed AI in some way that people really reacted either positively or negatively to. So that's a place, again, where what we're ultimately all talking about is trust. Like you want your consumers and your customers to trust you. And so that's a place where I think, and I certainly hope that companies are being really proactive in this space because it certainly don't want to be on the end of someone who was really surprised to find out how you used their data in ways they didn't expect.
And Molly, I think that's such an important point because we've focused, or at least I have focused most of this conversation on legal risk and the downsides of potentially violating a law. But for many people in our audience, a way to advocate for this internally does relate to brand protection, right? That where consumers are unhappy, they're not only going to submit the privacy rights request, Jody, that you described, but there are consequences for the business when consumers are surprised.
Privacy is a core business decision and a business value, and people engage with companies that they trust, and they don't engage with companies they don't trust. So, to me, this is where those conversations across the business lines really speaks for the value of what it is that you all do. Because the flip side is, well, if we didn't, what would our customers' response be?
Yeah, I think it's really important to have that conversation because it's that element of surprise. And if I'm giving information, if I'm giving personal information to an AI experience and I didn't know it was AI and I didn't know how it was going to be used, I might not have done that. And because that's new, there aren't as many laws yet. So a lot of companies are choosing not to put the disclaimers, and then the laws are catching, or there's an action and they're catching up, and then we're going to end up with a law that says why you can and can't do that, which is actually where we are today.
Mhm.
There are different cities and states that have AI disclosure requirements. Why? Because something didn't take place that probably should have in the first place. And if you start to blend the privacy requirements that we're talking about, think first, understand what's actually happening, think about the customer first, think about transparency, then that AI governance meets privacy, and you're able to really build something that's going to be defensible privacy, defensible UDAP, and defensible for AI governance. That's the way how I like to look at these kinds of things.
I agree with
We
all that.
have another question. Do you have any recommendations for emerging app-based startups concerning privacy protection? So I've encountered startups who have built a product without privacy controls. So I think let's make this a little bit broader, right? We have lots of companies here. There's oodles of startups all over the place. and this sounds like a great startup. Our company is trying to use this new tool in software. How can we help our audience be able to evaluate these companies who might be a little bit more nascent in privacy protection? Anyone have any thoughts?
Well, I mean, initial diligence is going to be important. And I counsel something as simple as take a look at the startup's privacy policy. If it doesn't align with state privacy law, that is a signal that we need to look. Our diligence is going to need to go a layer deeper before we even want to engage a company as a service provider, or otherwise as a vendor, because we want to make sure when we're partnering with a new company that it is able to protect any data that we share with it.
Amazing. Oh, Molly, do you have a thought you want to add?
I was just going to say, one of the things that other companies might think about, and I think Laura's point is excellent that, again, having a privacy program is really a core business function and value, and it really only will benefit your business to doing so. The government, I think the FTC used to have, and think they're still there, sort of resources for, and it was the Start with Security program that they did. And they were really sort of basic step-by-step things. But again, it was just a way to think about the sorts of things that Laura and Jody have been talking about in terms of how you go about identifying risk, identifying the data that you have. How are you going to keep it? How are you going to store it securely? How are you going to dispose of it securely, et cetera? So there also may be some really baseline tools out there, again, just to sort of get the juices flowing in terms of thinking things through.
Amazing. So I want to launch our last poll while Molly and Laura, you both think about a closing tip and thought that we can offer our audience. So you get like 30 seconds there. All right, audience, how are your compliance efforts coming along? This is a great time to start planning and think about where you want to go. So you haven't started yet. There's still time. Underway, but you have a long way to go. Underway and you're on track. You are all done. So far, no one's picked all done. All right. I'm going to close the poll. We have 66 of people are underway, but they have a long way to go. We have just under a third underway and on track, and just under 10%. You need to get started. We hope we have motivated you to getting started. And for those of you who have a long way to go, we hope we have helped. And in that vein, Molly, I'd love if you could share what is the closing piece that you want someone to take away here to get started for their 2026 year?
You know, when you posed that, I was thinking about it, and I guess the first thing I thought of, and the reason that I love this community and this space, is that the privacy community is actually both small and generous. And the nice thing about the people that we work with are that I have never known anyone in this field to not be absolutely open to taking a call, to having a meeting, to meeting for a coffee, to bounce ideas off of people. So use your resources, including your friends, that all the colleagues that you meet all over the place. Like you can just call somebody else and ask them what they're doing or how they might tackle it. And that's one of the things I love about the privacy community is it's so generous with its sharing and information.
I totally echo that. It's been that way for the almost few decades I've been in it. It's been quite remarkable. Laura, what about you?
Well, further to Molly's excellent point, yours too. I mean, privacy is a long journey, and regardless of where you are on that journey, what is important is to take the next step. And so, if you're one of that minority who needs to get started and it's daunting, make the phone call that Molly suggests, take that first step. If you are in an organization that has a relatively mature program, there's always room to improve because this space is changing. And so take that next step on the journey. And if any of us can help, we're here to do that, offer that support.
Wonderful. And my closing remarks would be to know your data and to really build in those operational processes. It will make complying with each new law, each new amendment, and each new change that much easier. You build the foundation, then you can get to those controls. So if you need any assistance, we have a plethora of knowledge and information on the Red Clover site. as well as the Kelley Drye site and the IAB. Oodles of resources at your disposal. And we are so grateful that you joined us today. Happy holidays, everyone, and we will see you in 2026.